counsel for the defense of Mr. Duterte. As everyone can see, Mr. Duterte is present and is attending the hearing via video link. As Mr. Duterte made a long journey involving a considerable time difference, the chamber authorized Mr. Duterte to follow the hearing at a distance. His counsel, however, is present with us in the courtroom. Thank you, counsel. Please introduce yourself.
Good afternoon, Your Honors. I am Salvador C. Medjaldea, counsel for Rodrigo Roa Duterte.
Merci beaucoup.
Thank you very much. Thank you very much, counsel. I will now introduce the chamber. By my side, we have the Judge Rain Adelaide Sophie Alapine Gansu, the Vice President of the Court, and Judge Maria del Socorres Flores Liera. I am the presiding judge of the pretrial chamber 1 of the court, and my name is Julia Antuanella Motok. Now, I would like to speak to you, Mr. Duterte. I'm speaking French, but you are receiving an interpretation of what I'm saying in English. I understand that you are at ease in the English language and that the interview yesterday at the detention center was conducted in English and that you did not deem it necessary to request interpretation into any other language during this interview. This said, I would like firstly to confirm your identity. Could you provide us with your full names, please?
I'm Rodrigo Roa Duterte. That's my first middle name is Roa. Surname is Duterte.
Merci beaucoup.
Thank you very much. What is your date of birth?
Again,
Can we request that the question be repeated? I don't think he heard it. Thank you.
Repetition from the English booth. What is your date of birth? Yes, thank you very much, counsel. I was asking quite simply of Mr. Duterte what his full names were, and then I subsequently asked him what his date of birth was and what his place of birth is. Is that all right, counsel?
yep. Of course I give. My birth month day is March 28, 1945. I was born in the province of Leyte in the Philippines.
Merci beaucoup.
Thank you very much. As a preliminary point. Very well. Thank you, Mr. Duterte. As a preliminary point, it is useful to clarify the nature and limited scope of this first appearance hearing. Today's hearing is neither the start of the trial, nor is it a confirmation of charges hearing. During today's hearing, no evidence will be collected or presented, and the issues of Mr. Duterte's guilt or innocence will therefore not be addressed. In accordance with Article 61 of the Rome Statute, the Court's founding treaty, and Rule 1211 of the Rules of Procedure and Evidence, the main purpose of this initial appearance is to answer 3 questions. Firstly, the chamber must ensure that the person who was the subject of the arrest warrant has been informed of the crimes of which he is accused. Second, the chamber must ensure that this person has been informed of his rights as recognized by the Rome Statute. Third, the chamber must set a date on which it intends to hold a confirmation of charges hearing. The chamber notes that your counsel, Mr. Duterte, filed two motions, one in relation with today's hearing, and you may be aware that these two motions have not been accepted by the Chamber because of the nature of today's hearing. No further discussion on the matter is necessary during this hearing because, as I said at an earlier stage, the aim of this hearing today is to introduce the parties and to ascertain the charges and to set a date for the confirmation of charges hearing at a later stage. With regard to the first point, I recall that Mr. Duterte has received a copy of the warrant for his arrest and that a redacted version of the prosecutor's application for the issuance of the warrant of arrest is public. I will now ask the court officer to read the charges against him. The charges will be read in English. Please, over to you, Madam Courtroom Officer. Thank you, Madam President, Your Honours. On 7 March 2025, pre-trial Chamber 1 concluded that there were reasonable grounds to believe that Mr. Duterte is criminally responsible pursuant to Article 25(3)(a) of the Rome Statute as an alleged indirect co-perpetrator for the crime against humanity of murder pursuant to Article 7(1)(a) of the statute as follows. A. Murder of at least 19 persons, allegedly drug pushers or thieves, killed by members of the Davao Death Squad in various locations in or around Davao City, Philippines between 2011 and 2016. B. Murder of at least 24 persons, allegedly criminals, such as drug pushers or thieves or drug users, killed by or under the supervision of members of the Philippines law enforcement, sometimes with the assistance of persons who were not part of the police, at various locations in the Philippines between 2016 and 2019.
Merci beaucoup, Madame la...
Thank you, Madam Courtroom Officer. Mr. Duterte, I'm not going to ask you to stand up because I know your condition, so I'm going to allow you to remain seated. You have just heard the reading of the charges, which are in accordance with the content of the arrest warrant you received. This means that you have been informed of the crimes of which you are accused. And this concludes the examination of the first point mentioned above. I will now turn to the second point, which concerns your rights as a suspect before this court. I will summarize some of these rights, which are of particular importance at this stage of the proceedings. Those rights are as follows. You can benefit from the assistance free of charge of a competent interpreter and benefit from the necessary translations to meet the requirements of fairness. You have the right to have the time and facilities necessary to prepare your defense and to communicate freely and confidentially with the counsel of your choice. You have the right to remain silent, and you cannot be forced to testify against yourself or to confess guilt. You can also make statements in your defense without taking an oath. In addition to any other disclosure provided for in the statute, the prosecutor must disclose to you, as soon as practicable, evidence in his possession or at his disposal that shows or tends to show your innocence or to mitigate your guilt, or that could undermine the credibility of the evidence against you. At the confirmation of charges hearing, you can contest the charges, challenge the evidence presented by the prosecutor, and present evidence. There will be no trial if the charges are not confirmed or if the proceedings against you are completed. You have the possibility to make an application for interim release pending trial. And finally, Mr. Duterte, you have the right to be informed as soon as possible and in detail of the nature, cause, and content of the charges in the language that you fully understand and speak. Counsel, have you understood?
We're listening, ma'am. We're listening. And before it ends, may we be allowed to present a manifestation on the circumstances behind the delivery of Mr. Duterte in this chamber.
Oui, maître, je dois d'abord demander.
Yes, counsel. This is as part of the procedure. And as we've said since the very outset, I need to ask Mr. Duterte himself to make observations as to the condition of his surrender to the court and the conditions of his detention at the detention facility of the court since his arrival. If he can please tell us these details.
Thank you. Can I...
Oui, maître. Oui.
Presiding Judge, yes, counsel.
Please. 2 days ago,
Book your hotel now and
to us lawyers, this would be called an extrajudicial rendition. To the less legally inclined, it was a pure and simple kidnapping. My client was denied all access to the legal recourse in the country of his citizenship, and this all in the nature of political score settling. Two troubled entities struck an unlikely alliance, an incumbent president who wished to neutralize and choke the legacy of my client and his daughter on the other hand, and a troubled legal institution subject to delegitimization and desperate for a price cuts and a legal show today on the other hand. With this in mind, it is not surprising that my client was abducted from his country. ICC private jets do not drop out of the thin air. That jet which received my client was coordinated in advance. The UAE is not a state party to the ICC and has no obligation to cooperate the court. Yet my client sat in transit in that country for more than 5 hours. I invite the registry's representative to present today in court to explain to the judges exactly how they believe this transfer was anything other than a gross abuse of process. Given the precipitous arrival of my client, an elderly man with debilitating medical issues, hard of hearing and poor of sight, he was taken to a hospital for observation. Only this morning have I met him for the first time with less than an hour to discuss legal issues. I have not been able to present him with a hard copy of the arrest warrant because we were not supplied with such. I have not even been able to explain to him what the prosecution requested when seeking the issuance of the arrest warrant. This is because the chamber only established a redacted version of the prosecution request last night. Other than to identify himself, my client is not able to contribute anything to this hearing. Most importantly, he is not able even to tell you that he has been informed of the charges as contained in the arrest warrant a reason more pertinent to which I alluded in my written request to this honorable pretrial chamber this morning, and which is confidential in nature. Accordingly, I repeat my respectful request, which was rejected this morning, to postpone the substantive aspect of this hearing to the next week, when I will have the opportunity to sit with my client and to explain to him what a confirmation hearing is and what the disclosure is, and how the prosecution alleges that he committed crimes. I thank the court for its attention and regret to say that I do not have instructions to continue my submission any further today. Thank you.